Katie. All persons having anything to do before the Honorable, the Justices of the Appeals Court, now sitting at Boston within and for the Commonwealth. Draw near, give me your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is open. Please be seated.
Good morning, everyone. Welcome to this one case sitting of the Massachusetts Appeals Court. It is my great privilege to be sitting today with Justices Milkey and D'Angelo, and I am Justice Wolahojan. I think you both know the rules of the road here. 15 minutes per side, no rebuttal. The yellow light goes off a minute and a half before your time is up. We recently had our bench bar conference, and I heard loud and clear that counsel would like to have some uninterrupted time at the beginning of their argument. And so we're going to try that today. So minute and a half, if you want it. But if you want to just stand up and see what's on our mind, that's okay too. But we really do want to be respectful. But at the same time, we do probably have questions. So with that, I'm going to call the case. Please remember that the case is partially impounded, and so not to refer to the impounded material in court, which is normally names. Probably in this case, only the child's name. And the case is 2023P 0222, Ryan Jordan versus Kay Mulvey. And Attorney Reedy. Thank you.
Good morning, Your Honors. May it please the Court. James Reedy for Kay Mulvey. And while I certainly appreciate and encourage the minute and a half of time to set forward the case, not having prepared for that, I'm afraid I might stumble through it and would be prepared to jump into the first issue with this exception. Both parties had filed a motion with the Court relative to the First Amendment issue, and I'm not sure where the Court stands with that, if the Court's wants us to argue it or no. And the motion had to do with the fact that the First Amendment issue was there was a subsequent judgment by the probate court indicating that its order that is the subject of the First Amendment issue was erroneous, and it then removed that order in the court. I think there's a little bit of a technical open question as to the extent that the trial court had the ability to make that judgment. I think both parties are in agreement that should the second judgment be considered valid by this court relative to that particular issue, that First Amendment issue is moot.
As I understand it, that issue is moot so long as we accept what the trial court did. And I'm not sure I'm aware of our court ever preventing the parties from mooting an issue.
Are you arguing that subsequent order, I take it you would not be arguing that the subsequent order is erroneous?
I certainly would not. I think
right, you would not be arguing that. So if you're not arguing that, then your position here would be that the First Amendment argument you raised in your brief is moot.
Correct, as noted in the footnote
right.
that I put with the heading on that particular argument. So if I could, I'll jump into the first issue relative to school. Although not applied by the trial court, and certainly not particularly raised by the parties in the trial court, I'd suggest that the standard applied by the trial court here was incorrect because we have fundamental rights of both parties, both parents involved, and that where there is a conflict of fundamental rights, the Due Process Clause applies, and the court is required to have a higher standard of proof, or excuse me, a higher standard relative to the order. The strict scrutiny standard applies, and that suggests where fundamental rights are at issue, although among parents, when there's a conflict, although that has not been addressed, particularly in the area of school choice. Although it is quite clear that...
The father argues that this issue was waived. It was never raised.
He does, but he relies on cases that come out of the Appellate Tax Board, which is this sort of different animal. And I'd suggest what the Appellate Tax Board is essentially stands almost as an appellate court to the decision of the taxing authority. Taxing authority makes a decision.
Okay, but put the ATB aside.
Okay.
Generally, an issue needs to be raised in the trial court long before it comes here. Was this issue
Generally
raised?
it does. However, the SJC and this court, to some extent, has made clear that the decision of the standard of review, or the decision of the proper standard to be applied, is subject to almost de novo review, I'd suggest, by this court. And I think the reasons for that are very simple. If the parties in the court have an erroneous standard, the appellate court can't have decisions where they say, well, this is the wrong standard, but it applies because the party said this was the wrong standard. For example, if I can use something a little basic on a domestic case, if there was a removal case, which is somewhat familiar here, where the parents sought to remove a child out of state, the standard is what is in the best interest of the child. Let's say, for example, the parties erroneously said it's what's in the best interest of the parent, and the court agreed with them and said what's in the best interest of the parent, and applied that standard to removal. If the losing party, the aggrieved party, came before this court and said, that was the wrong standard, it really should be what's in the best interest of the child, this court wouldn't say, well, we hear you, and that's absolutely the wrong standard, and that's not the standard that should have been applied, but because nobody raised it, we're going to review the case under that erroneous standard. I'd suggest they would apply the proper standard. They may remand the case back, but they would apply the proper, at least say that the proper standard was.
I'm a little bit confused. Are you arguing that when a trial judge applies the wrong legal standard, that results in a violation of due process?
No, what I'm saying here,
So then what is your due process argument?
due process argument is where there's a fundamental right at issue, and we know that care of your children is a fundamental constitutional right. Due process applies. And we also know that school choice is involved.
You got procedural due process, right? So what's the due process violation?
The due process violation is this. The standard that should have been applied here is a substantial harm to the child.
So that goes back to my question, which is, are you claiming that by using the wrong legal standard, that results in a due process violation? Because
Correct.
I don't, all right, but then I'm not 100% sure why that isn't just an argument that the judge erred by using the wrong standard
It's a little
for
bit of
the
both, Your
issue.
Honor. I'd suggest it's a little bit of both. I think part of it has to do with.
How does it become a constitutional claim as opposed to just an ordinary claim on appeal that the judge used the wrong standard?
For two different reasons. I'd suggest that part of the judge using the wrong standard down below is addressed by is designed to be addressed by the issue of waiver within this court, whether it was possibly waived or not, and that it is the court, the appellate court, which applies the correct standard. I'd say, secondly, the order itself is the due process violation in the sense that that order was an order to send the child to public school, which that particular order was violative of the due process rights of Ms. Mulvey to send her child to private school.
All right, so,
Because it's an order compelling where he goes to school.
no, I understand the order. I'm wondering why it's to your advantage to try to make this into a constitutional issue.
I'd suggest it's twofold. I think, one, it's quite clearly what applies and what the standard should have been applied below. Or
Well, okay, so then why wouldn't you just argue the judge used the wrong standard, this is the right standard, so it needs to be reversed? How does this advantage you to try to frame it as a constitutional issue?
So parents have a fundamental right for that school choice, and both parents are in conflict relative to that school choice. It is not.
Just to be clear, is it any school choice you're talking about, or is it because this happens to be a Catholic-based?
We didn't make a religious liberty argument.
So it's just, from your perspective, any school choice is a constitutional issue?
I would think, at least in this case, we could draw the line between public and private, and I don't think there has to be, the court wouldn't necessarily have to address whether public versus public, whether it's a school district issue involves that fundamental choice.
So, in your view, removal is a lesser interest than school?
Yes, and I'd suggest.
All right, so then, if it's not best interest of the child, what is the standard the judge should have used?
That it's a substantial harm standard, and I'd suggest it would be.
To whom?
To the child. And I would suggest that
Where do you get that from?
so I get that from
Need a case. I need some kind of legal authority.
Sager versus Sager, which, as I sort of laid out earlier, doesn't address particular school choice. Sager,
The religious rights.
it was the religious rights, but Sager talked about it in the context of a parent's due process fundamental right for the religious choice of their child.
Right,
When
but you're
Lang-
not talking about that here.
I understood. When Lang forth that argument, however, one of the anchors that this court put forward to anchor his decision discussed fundamental rights of the child in care of their child. There is other case law which is addressed within the brief, actually they address it in part in Sager, that educational choice are one of those considerations for
Do any
for
of
care the
those
child.
cases involve choice between public and private school, where there's no other component alleged? There's no inadequacy or religious component or anything, it's just a difference between public and private?
There is nothing else that deals with that. The only
Okay.
cases that really
And
deal
then
with that
the
deal
other
with the context of
question I
separation
have,
agreements.
the other question I have for you is, I take it that if the standard were what is in the best interest of the child, you're essentially conceding that you would lose, and that's why you want this higher or different standard.
I wouldn't essentially concede that,
But you're not arguing it.
I wouldn't suggest that we would consider that we would lose, because I think I don't think the best interest of the child standard is general were met. I do think that is a little bit hamstrung by, quite frankly, the abuse of discretion standard that's applied by this court.
Now, the judge seemed to use public schools as a default.
Correct.
Both schools were adequate, and the judge said, okay, if they can't agree, public. And as they agreed a while ago, what's wrong with that?
So if I could address those questions in two parts. First, the judge said that. There's no case law I could find that says public school is essentially the default, which I think is why we get back to that idea of we have fundamental interests of the parents at heart, and it is probably up to a court to resolve where you have two choices to be made relative to school. There's nothing to say that public school has to be the default, or that where two parents who are legal custodians disagree that public school is automatically the default, and that the parent promoting private school or wanting private school has to come to the court and make a case for why the private school would be the better option for the child. I would also suggest that, to get back to the idea that the court was really anchoring this into an agreement between the parties.
Well, the judge considered what father wanted, what mother wanted, what was in the best interest of the child. How is that an abuse of discretion? She considered all the factors.
So I would go back to it, which is why we're discussing the fact that it's a higher standard of substantial harm, because a due process right is involved. That it is not simply that abuse of discretion. It's not simply an abuse of discretion standard that whether the court applied the correct standard or not. We're arguing that the court did not apply the correct standard. But if I could get back to the issue of this agreement, there was obviously a dispute relative to there was an agreement. The court came down on a particular side of that dispute. However, what I suggest is what the court didn't entirely credit was there was a dramatic change in circumstances, two particular ones that occurred in February of 2020, or in the week subsequent, which was the COVID-19 pandemic, which had a dramatic effect on schools and what those schools would look like. And secondly, the fact that son was diagnosed with learning challenges. Those learning challenges, which would have been directly addressed by the school that he was at under using the guide of Dr. Kemper, the recommendations that he set forth, that those were going to be done right away, day one, when he was back at school, and furthermore, that school was coming back in person full-time, and that given the tumultuous nature that occurred within the educational system with the COVID-19 pandemic and how schools were trying to react to that, that was not, I think, something to be cast aside when deciding whether mother made a decision that was, at least in her mind, in the best interest of her child.
What's the current state of play?
The child is currently at the school that he'd been at
How is that possible, given that the injunction went into effect a year ago?
because both parties agreed prior to the school year They met, they discussed, they both agreed that the child would remain at North Shore Christian for this year. I don't know specifically, but I think obviously this pending case probably had something to do with that. But that was an agreement that both parties made, which was consistent with the order, because the order said has to go unless both parties agree otherwise.
And on the doctor issue, what's the state of play?
On the doctor issue, there has been a new doctor chosen. I would suggest that that issue is still viable for this reason. I think that there is at least something that comes out of that order, which is unclear on whether as to who has ultimate medical authority, whether it was only limited.
That's not what the order dealt with. The order dealt with the identity of the doctor.
Absolutely.
It sounds like there is an agreed-to doctor, or
So
the parties agreed to select a new doctor, so why isn't that issue moot?
So I would suggest that part of it deals with how this case has gone forward. I would suggest that there is a little bit of wiggle room there, enough that that issue of who is to make medical decisions. I understand the court's point. I certainly think that that is probably the strongest way to read that order. I would suggest that given how this case is gone forward, that will be a potential, in all likelihood, a potential for future litigation. I think that there is at least an open decision about an open question whether that door is wide open or whether that door is slightly open about who has the right to make medical decisions when it comes to doctor and subsequently to potentially changing a doctor.
Okay, we're going to have to leave it there unless there are any other questions. Thank you. We
Thank you,
have
Your
your
Honor.
argument. Attorney Durland?
Your Honors, Sandy Durland, Warner, Federico, and Ryan in Boston on behalf of Ryan Jordan. Good morning. I'm happy to take any questions that the panel has. I don't necessarily feel the need to pontificate for a minute and a half. I'm happy to do so if Your Honors don't have any specific questions to start.
So I had a feeling, actually, when at the bench bar conference, that people wanted something told us they wanted something that they didn't actually really want, but I'm trying to keep an open mind when people tell us what they'd like. I do have a question for you, which is, I'm puzzled about whether the judge, it didn't appear to me that the judge really put the child's best interest front and center. Can you point in the decision the judge seemed to really use some sort of contract-based analysis, that the parties had agreed to this, that because they had agreed to it, the mother wasn't allowed to then renege on the agreement, especially unilaterally, as opposed...
Respect to school.
With respect to school, yes. And that doesn't... I understand that. I understand why the judge was troubled by that, because inability to stand by one's word is certainly an indication of something. But I'm not quite sure that that's the legal standard. The legal standard, I believe, for the judge was what was in the best interest of the child with respect to schooling. And when I saw the judge's findings, when I read the judge's findings, it appeared to me sort of to be an equipoise, that both schools were found to be sufficient. Both schools provided special needs supplements.
Right.
There's probably a little bit of a plus on one side in that the child had friends and contacts at the existing school. There's a minus in that it's a private school and it requires a payment, but that's maybe, offset by the fact that the parent who wants that school is willing to shoulder 100% of the cost. In the end, I didn't see a clear sentence, but perhaps you'll help me find it, that says, taking all of that into account, I find the Beverly Public School System is in the best interest of this child because.
Well, I think the judge found that both schools appeared to have been would be adequate to meet the child's needs. The IEP came from the school, which was then adapted by the private school's own variation of that. I think I didn't read, Your Honor, I didn't read the findings to be based solely on sort of a contract concept. I think it's more like what Justice Milkey said. It was more of a default, because there were a number of different issues between these parties that they disagreed on, school being one of them, and other choices and the father's role in the whole process. And I think Judge Anderson looked at all that and said, ultimately, they don't agree. You've come to me, I'm stuck with this decision, and if you don't agree, we have to default to the public schools.
All right, so let's accept that. Let's accept that it's default. That also doesn't seem to me to be necessarily equate to child's best interest, right? Because what if the default is not in the child's best interest? If it doesn't seem to me you can just substitute, whether it's contract-based analysis, whether it's some notion of default, without also taking into account what is in the child's best interest, because what is missing in my reading of the decision, which I'm waiting to be corrected on, is does the judge connect her findings, such as the IEP came from Beverly, the private school has implemented it, Beverly is good, the private school is good. Does the judge then take the pluses and minuses and say it's in the child's best interest to be in the public school rather than the private school on some basis other than a notion of like public school is the default?
Well, I think the judge looked at the whole process and felt that the father's role had been diminished to such a degree.
I get that.
That something had to be done, and since there was not an agreement, he was going to go with the default. And it just so happened that, in Massachusetts, like undoubtedly anywhere, when there is a dispute over schools, private versus private, public, what have you, or even two different school districts, there has to be a decision, and the judge was saddled with that.
Who had the burden in this case?
Who had the burden? Well, they both did, because they both they both brought claims for modifications.
Okay.
They both sought sole legal custody over this decision.
So so each had the burden to prove what?
They had a burden to prove a change in circumstance.
And in this case, the change in circumstance would be to remove the child from private school to
based on a
public
panoply
school?
based on a panoply of issues.
Okay, so first they have to establish a change of circumstance, and then what do they need to establish?
Well, I think that's the crux of the issue. Once the change was established, the judge was then required to make the decision where the child would attend, public, private.
Based on what standard?
A best interest standard.
Best interest standard.
Not in I can get to
Right,
the fundamental rights issue, but
Yeah, I'm not so, to be frank, I'm not so
Well-
interested. I think I have a more core problem, which is best interest. I don't really see this as a fundamental rights issue, but I'm sure I will be corrected by my co-panelists. And I guess what I hear you saying is that the judge did not explicitly explain her decision in
Well-
terms of best interest,
Well,
but
he
rather
did-
in,
I'm sorry.
Sorry.
I apologize.
no, go right ahead.
He wasn't given sort of, sometimes in removal cases, you'll see experts who compare school districts and SAT scores and college application rates and all that sort of thing. That wasn't the case in this situation. So he was given, information about how the child was doing at the North Shore Christian School. There was no competing information, if you will, regarding the public school. So ultimately, this did come down to a default-based decision, as Justice Milkey pointed out.
Right, because there was no head-to-head comparison between
No,
the
there wasn't.
schools. There was no, so,
But I think you have to look at it, it's more than just, it's father's role, and father's role in his son's education is an important component.
Well, I get that,
of that
and I
best interest
understand the
decision.
judge's, and I understand the judge's frustration with the mother's approach here.
And I think that was a critical component, and it was certainly a key decision. It was a key part of the calculus, to be sure. I don't think it was the only calculus, but it can't be denied, without question.
I guess I'm like Justice Willahogian, which is, you keep saying it's the default. That's not the standard. The standard is, what's the best interest of the child? And to me, reading the findings, the judge didn't really make a decision on that. And isn't that something that needs to be decided by the trial judge and not us? It's one thing if she had said, it weighs ever so slightly in the Beverly Public School, therefore I'm going to choose the Beverly. To me, the findings were, they're both really good, they seem to be working well, I'm not sure, so I'm going to pick the default, I'm going to go to Beverly. How is that the correct standard?
Well, because I think a judge is confronted with competing claims, private versus public, the judge has to make a decision, one way or the other.
Doesn't that mean the judge has to make a decision which one is in the best interest of the child?
He did make that finding here. It was a broad finding, but he did it. At the very beginning of his findings, he did say the decision in this case was made in consideration of the best interests, and I have determined they are in the child's best interests. So the finding was made, and I do think it has to be looked at as a whole and not as narrow-driven as to whether or not he was getting A's versus C's or what have you, or whether, the school class size in Beverly Public is a lot bigger than the school at North Shore Christian. Ultimately, I think the judge looked at the whole thing and said, there is a pattern in this case of dad being excluded, and that is not in the child's best interest. And one way to rectify that is to have father be respected in some respects. His view is that the public schools are what this child should do. I'm going to make that decision, but it's not just based on what dad wants.
Let me ask you a question on that. So if a child is attending, and I'm going to use a private school, but it could be a public school. Attending a private school is doing very well. It's a great private school. But dad, in order to execute visitation, has to travel 2.5 hours both ways. And the judge says, I'm taking everything into consideration, including dad's visitation and how much time he should spend with the son. So I'm going to pick that and say the child should go to the public school, which is closer, even though I find that the school is better, the private school. Would that be a correct decision by the judge?
I think it could very well be, Your Honor. I mean, the reality is you consider a host of different issues. Doing well in school, traveling 2.5 hours to see his father. All of it plays into the calculus, and all of it is idiosyncratic to the case.
Well, so I could imagine that in Judge D'Angelo's hypothetical that there might be a factor that weighs in the child's best interest to facilitating visitation with the one parent by diminishing travel. But here, I can't tell what helped the child, what made Beverly Public School better for the child than the private school placement. I can't tell from the judge's findings what made it better for the child to go to that school.
Well, I have to, acknowledge what the evidence was.
That's why I say the evidence seems to me to have been in equipoise. The two schools seem to have been both adequate and perfectly adequate.
Exactly. The judge said that, there was nothing given to me to suggest that the Beverly schools aren't anything but, sufficient. And, with that in mind, in light of the other considerations, I believe the best interests drive it to this result. So it's not just, a school choice good versus bad. It's a host of considerations. It's a challenging situation.
Yeah.
And as you pointed out, the judge was frustrated in this case.
Well,
and I think it had a lot to do with, the result that he came down with, but it was not the only decision, or it wasn't the only factor, I dare say.
Now, you heard counsel forswear relying on the religious nature of the school as invoking the mother's fundamental rights, etc. My recollection is that part of the father's objection to this school was that it was too religious. Can we avoid any consideration of aspects of this case that involve religion?
Your Honor, I didn't read her argument to be necessarily religious-based and more...
No, I'm saying she has forsworn that.
Sorry.
But I'm saying, can we avoid that necessarily when part of the father's objection to this school was that it was too, in his view, too religious?
Well, I think that is I don't know to what degree that drove Judge Anderson's decision, but I think certainly a parent's objection, whether it's religion or something else, Montessori, if you will, I don't think that is an inappropriate consideration for a judge to consider, because each parent's viewpoint should be part of the calculus. And father's objection to the religiosity is certainly just one of the considerations. I don't think it was a driving consideration here at all, personally. I didn't read it that way. I'm not sure Judge Anderson did either, but I'll leave that to your Honor's decision on that.
I assume since you're here, despite the fact the child being at the same placement school and I assume doing well, father still objects to the child going to that school.
There was a procedural-based reason for the child remaining in the school. It had to do with hearings before Judge Anderson, when they occurred, and it turned out that the school, the issue about where this child was going to go to school was sort of still in flux just before the new school year started, and father decided, okay, we're going to keep this status quo in part. To answer your question, yes.
And just on the doctor issue, is that issue moot?
I think it is.
Okay.
At least it has been decided.
There are no further questions. And with that, the case is submitted. I will just say that if your clients are present,
They are.
the courtroom is in my humble view, the least beneficial forum in which to try to resolve questions such as this. And it is not surprising to me that the judge below took into account the apparent inability to agree and respect each other's views in the calculus of what is in the best interest of the child. Harmonious relationships between parents is the single most beneficial thing to the child. I speak from the love and respect I have for my parents when I say that, and I just mention it today. So with that, the case is